The criminal justice system is what I want to talk about tonight. And to start with, I want to say that we actually have two tracks of judicial system in the country. The first one is the criminal justice system, and it's responsible for maintaining a balance between an orderly society and preserving our basic freedoms. The second track is the civil system, and it provides us with the ability to resolve issues between individual citizens and to right injustices. The biggest difference in between criminal and civil system is that in the criminal system, the defendant faces a punishment which can include jail time, fines, and restitution. In the civil system, it usually involves only monetary settlement or maybe some other type of transaction, but there's never any jail time involved in a civil case. The roots of our modern jurisprudence find their birth from English common law. When the settlers came over here, they actually brought an idea of what a lot of the ways that you could handle criminal problems could be handled. What occurred was that the government really didn't get too much involved. They allowed families or individuals to resolve those issues. It was decided at some point that because many times the retribution for a crime by one individual to another was considered to be excessive, that the government probably needed to get involved in this. So that is what they began to do. A lot of people don't realize that the Constitution was not the first governing laws that we had in this country. We actually had the Articles of the Federation, which was enacted in 1781 to really pull together the 13 states that were in the Union at that time. In 1787, then our forefathers got back together and they drafted and enacted the Constitution. In 1791, they added the Bill of Rights, and the Bill of Rights is actually where we see a lot of our rights that are protected now, such as the right to be found innocent until proven guilty, to protect us from overzealous government control. All of our rights came from the Bill of Rights. We have constitutional law today, which has to do with the governing of the protection of rights in the Constitution. We then have federal and state statutory law, and those laws set up by the federal government as well as state government, which is what statutory law is, where the statutes all have to comply with the constitutional law to ensure that our rights are protected. Federal and state statutory law are the actual defining laws that say what is a crime and what are all the particulars of those crimes. We then have case law, and case law is actually cases that have been tried in other places that have similar facts, and they're usually precedent-setting cases. And that gives some guideline for other judges, prosecutors, attorneys that are looking for information to see how these decisions or how the law is being applied, can actually look at case law and compare the likeliness of those cases to theirs in order to see how those decisions have been made so that they can argue in court in support of whatever their position may be. We also have protection actually against ex post facto law, and that comes directly from the Constitution. The Supreme Court has actually defined 4 factors in saying what is considered to be ex post facto law. And the first one is laws cannot be put into place that make an act retroactively criminal. The second one is a criminal offense cannot be aggravated retroactively for 6 months prior to the offense. Laws cannot increase the punishment for an offense retroactively, meaning they can't go back on a law that was, say, the punishment has changed, and if the older law was more the punishment level was higher, they can't go back and use that punishment level against you. Also, the final fact is that the rules of evidence of a law cannot be altered to require less or different evidence retroactively, meaning that whatever the current law is and whatever it requires as far as evidence, that is the one that the prosecution has to use whenever they're prosecuting you for a crime. We have burden of proof also, and burden of proof has three categories, two of which are for the civil jurisdiction, and that's preponderance of the evidence and clear and convincing evidence. However, beyond a reasonable doubt, which is a higher degree of burden of proof, is what's used in the criminal justice system. There is some discussion right now because it's not been clearly defined by the Supreme Court what beyond a reasonable doubt is, but they are very steadfast that it is one of our given rights constitutionally, and hopefully over time the guidelines for that will become a little bit more clear so that it is more evenly used against each person so that we see like results. A crime has 5 elements. The first element is actus reus. Actus reus is the actual act. Mens rea is the actual emotional knowledge that you're committing a crime. We then have concurrence, which means that actus reus, or the proof of the act, and mens rea, meaning you knew you were creating or doing a crime, are both evidenced. So that's what concurrence is. We have causation, which means that your act directly caused the injury or the crime. It was a direct result of. And then we have the resulting injury or crime. So those are the 5 elements of a crime. There are many legal defenses against a crime. I'm going to discuss some of them here with you. The first one is affirmative defense. An affirmative defense is when the defendant admits that he did do the crime, but he's saying there's extenuating circumstances that are the reason why he committed this crime and why he feels he's not guilty. We have immunity. Government can grant immunity to witnesses. We have diplomatic immunity, and that means that they are protected from prosecution. We have mistake or ignorance of fact, meaning that you didn't know that you were committing a crime, and that's not a very effective defense. In fact, that's very rarely ever used. If you think you're doing something wrong, you probably are. We have intoxication or drug condition. The only time that that's going to be accepted as a defense is if you were involuntarily forced to become intoxicated or under the influence of a drug. We have duress, coercion, or compulsion. And that normally is only going to hold as a defense if you can prove that you were under immediate and direct threat of a murder, of death or of a serious injury. We have a necessity or choice of evils, meaning that you were faced with 2 different choices. You took what you considered to be the less of the 2 evils, but it still ended up being a crime. We have the defense of self-defense. We also have alibi, and that means that you may have a witness as an alibi, but that witness has to be supported by corroborating evidence. We have double jeopardy, which means that you can't be tried for a crime twice, and that's a constitutional right. We have entrapment and outrageous government conduct, meaning the government was very much responsible for setting up the conditions and bringing you into the conditions that got you involved in the crime. We have another person committed the crime, and people are a lot more familiar with that when you see DNA evidence ending up not matching the person who's been prosecuted for the crime. We have the right to a speedy trial, meaning that we are protected, that the government can only hold you for so long and they have to prosecute you within a certain matter of time. We have the expiration of statute of limitations. Pretty much every statute has a statute of limitations on it, and I do believe that murder is the only one that does not have a statute. So no matter what crime you commit, at some point normally they all have a point where they can no longer prosecute you for anything. And finally, I'd like to say thank you very much to Professor Moriarty for conducting the class for us. I learned quite a bit, and I want to say thank you. Thank you. Bye.